Hello, everyone. I'm Elizabeth Wydra, president of the Constitutional Accountability Center. Thank you so much for joining us here today for the 9th annual Home Stretch at the Supreme Court event. It's the event where we look back at the term thus far and look ahead to the big cases still to be decided. We have an all-star panel today led by our moderator, Greg Storr, Supreme Court reporter for Bloomberg News. He will lead our conversation featuring the executive director of the MacArthur Justice Center, Amir Ali, Berkeley Law professor Kiara Bridges, CAC's own Chief Counsel Brianne Gorod, and University of Texas School of Law professor Steve Vladeck. But before we turn to our fabulous panel and focus on specific aspects of this term and issue themes, I want to talk a little bit about feelings when it comes to the Supreme Court. When I look at the court today, I think a lot of us, myself included, see a complex mix of joy and pain. And this is probably where it's good we're not in the our traditional National Press Club in-person setting, because if you're at home and you want to sing along, my fellow 80s, 90s babies, sing some joy and pain, go right ahead. Maybe it'll make you feel better when you are thinking about what we're facing at the Supreme Court. But I will start with joy because I'm inclined to borrow Senator Cory Booker's line from the Senate Judiciary Committee hearings for Judge, soon-to-be Justice Ketanji Brown Jackson. No one's stealing my joy right now. I think that goes for me and for millions of people around America when we look at her historic confirmation. Justice Jackson, because I'm already calling her Justice Jackson, even though she's still technically judge for another minute, she will be an outstanding addition to the Supreme Court. She has a powerful commitment to equal justice. She's repeatedly demonstrated her commitment to the text, history, and values of the whole Constitution. She understands how the law affects people, drawing upon her professional as well as her lived experiences. And after 233 years and 115 justices, she will be not only the first Black woman Supreme Court justice, she will also be the first member of the High Court to have once served as a public defender. Now, some have tried to, if not steal, downplay our joy by noting that Justice Jackson will not change the ideological balance of the court. But to that view, I heartily dissent. And yes, that is probably something that we will be hearing from Justice Jackson quite a bit, at least in the beginning of her tenure on the court. But her presence will be meaningful and powerful, even if it does not, at the beginning of her tenure, change the ideological balance of the court. It is meaningful and powerful to have the first Black woman on the court who has spoken about how in one generation her family went from segregation to the Supreme Court of the United States, knowing the ways in which the law has both helped and at times hindered that journey towards perfecting America's union. It is meaningful and powerful to have a public defender on the court, a perspective that is sorely lacking on both sides of the ideological spectrum on the Supreme Court. I still remember that moment during Justice Amy Coney Barrett's hearings when she acknowledged that she'd never been inside a jail or a prison. And to think that, frankly, she's probably not the only one, even though there is extraordinary power, even though the court has extraordinary power over the criminal justice system, prison conditions, and the rights and liberties of incarcerated people. Justice Jackson's role on the court will be vitally important now and possibly only more so in the future. After all, today's dissents can be tomorrow's majorities, for better and for worse, which we might talk about today when we talk about the shifting majority, now a 6-3 strong conservative majority on the Supreme Court. But while we rejoice at this momentous event in American history, we must acknowledge that, on the other hand, there are ominous clouds hanging over the Supreme Court. And I don't even have time to get into the shadows cast by the deeply problematic shadow docket, though I'm sure since we have an author of a forthcoming book on the shadow docket, we will be getting into that today. With us today, Steve Vladeck. But yes, we cannot look at the Supreme Court without seeing those ominous clouds. The right to abortion hangs by a thread. The power of the federal government to protect our environment is on the chopping block. Voting rights and civil rights are being pushed back instead of being moved forward. In short, many of us fear that the court, with its 6-3 conservative supermajority, is poised to deal a great deal of pain to the American people in the weeks ahead. As a leader of a progressive organization, I join millions in America who look to the Supreme Court with great trepidation. But as difficult as these times are, I also know that we cannot back down from the fight, that we must fight our nation's critical battles in the Supreme Court as well as the lower court. And yes, there are important victories that we can and must win there. Amir Ali on our panel today is testament to that fact, having won just this term an important case vindicating access to courts and government accountability. So as we have since our founding nearly 15 years ago, CAC will continue to direct the court's focus and hold the court accountable to the text, history, and values of our whole Constitution. That is our North Star, and it is on that course that we know victory is won. So thank you so much again for joining us today. And now it is my distinct pleasure to turn the program over to Greg Storr. Thank you, Greg.
Thanks, Elizabeth. Thanks to the Constitutional Accountability Center for letting me moderate this pattern. Hi to my colleagues in the press corps out there. Apologies to anybody who was hoping for another moderator named Storr to be here today. We're going to start with the Mississippi abortion case. That's, of course, the case over the 15-week ban in Mississippi and the prospect that the court might overturn Roe v. Wade and Planned Parenthood versus Casey. Kiara Bridges, why don't you, I want to give you a chance to say what you want to say about this case, but kind of the conventional wisdom, and I would say the growing conventional wisdom, is that this is either going to be awful for abortion rights or extremely awful for abortion rights. That is, either they leave Roe v. Wade on life support or they overturn it outright. Do you share that conventional wisdom? If not, what reasons for hope do you see in this case?
Yeah, thanks for the question. So I start from the premise that abortion rights are already terrible. Like even, the status quo right now is terrible when it comes to access to abortion. If one is privileged, if one has race privilege, class privilege, if one lives in a city, abortion is available. One can purchase it in the market. But when one is unprivileged, when one is poor, a person of color, undocumented, has a disability, is young, then abortion rights exist only in theory right now. And so when we're talking about what the Supreme Court is about to do in Dobbs, right? So the options are either they're going to eviscerate Roe and Casey entirely, or they will just eviscerate the viability line. Both of those represent regression, right? It's a retreat from what is already a terrible state of affairs. And so, there's very little reason for optimism. I guess the only source of optimism may be in the likelihood that the Supreme Court's decision will sort of spur activism. It will cause people to, take to their state legislatures, take to the streets to demand protection for the ability to control what happens to one's body.
Let me ask you a quick follow-up and then open it up to the other panelists. If the court overturns Roe, what happens next in terms of the law? What are sort of the next things you might worry about on your side for what the court might look to overturn next?
Right. Yeah. So, I think when it comes to abortion specifically, we are going to have to start paying attention to the ways in which states will try to restrict the ability of people to access abortion anyway. So we're seeing a spate of laws from anti-abortion states trying to criminalize travel, right? Trying to make it illegal for people to leave the state in order to access abortion in other states. So we're going to have to keep our eyes on the law, developments in the law, to see whether those laws remained legitimate. It's very reminiscent, to me, of Loving versus Virginia, the case in which the Supreme Court struck down anti-miscegenation laws, but the Lovings had traveled out of Virginia to DC to get married. And when they returned to Virginia, they were arrested under a statute that criminalized leaving the state in order to engage in an interracial marriage. And so we're seeing kind of a revisiting the rearrival of those laws that are criminalizing travel. We'll also have to pay attention to laws that attempt to make it illegal for people to access medication abortion. And I think that we're going to have to be attuned to how states try to make medication abortion less available, but also criminalize or otherwise prohibit the access to medication abortion. So those are sorts of things that we have to sort of be on the lookout with regard to abortion access specifically. But I think that we all know that abortion, Roe v. Wade is just the beginning. I think that the right will celebrate the fall of Roe. They will celebrate the evisceration of Roe. And then they'll think about what's next. They're already thinking about what's next. Substantive due process hangs by a thread. And Roe v. Wade doesn't just hang by a thread. Substantive due process entirely hangs by a thread. And so we need to be aware that the right is looking to not just overturning Roe, but also looking to overturning Lawrence versus Texas, also looking to overturn Obergefell versus Hodges. When it comes to reproductive rights specifically, all of our reproductive rights are sort of housed in substantive due process. And so the right to access contraception, the right to not get pregnant in the first instance, Griswold versus Connecticut, that hangs by a thread. The right to parent your kid in the way that you see fit. That is actually, based in substantive due process as well. So we're talking about Nebraska, Meyer versus Nebraska, and Pierce versus Society of Sisters. All of those are substantive due process cases. All of those are deemed to be illegitimate. First, it started with Clarence Thomas writing concurrences in which she was like, what is this substantive due process thing? And now we have Gorsuch sort of joining into those concurrences. And so in those dissents. And so I believe that we need to be attuned to how the court will continue to delegitimize this long line of cases and render illusory the rights that we have relied upon in order to be fully human in this country.
Let me open it up to the other panelists, either for questions or your own thoughts on what Kiara just said. Brianne, you want to say something?
Sure. I hate to be even more depressing, given the depressing story we've already, rightly heard from Kiara. But I thought it was worth mentioning that, kind of regardless of what happens in Dobbs, the court has already signaled to the states, in the way it handled the SB 8 litigation earlier this term, that they can nullify Roe, they can nullify other constitutional rights that they don't like within their borders, and that the Supreme Court is going to let them get away with it, at least when it comes to rights that a majority of the court doesn't care that much about. Folks will recall that SB 8 was the Texas law that was really just a brazen attack on Roe. And it was crafted in a manner designed to evade judicial review by delegating enforcement to private individuals. And, in litigation before the court earlier this term, the court basically said that was fine. And, it's devastating to Roe. It's devastating to constitutional rights. And it's devastating, really, I think, to the court itself as an institution. I think one of the things that folks talk a lot about when it comes to the court recently is its legitimacy, its integrity. We know this is something that the Chief Justice, cares a lot about. And this was something that the point that he made, in his opinion in the case was that, what Texas was trying to do was say, we can nullify decisions of the Supreme Court. And it shouldn't matter what right is at stake. And so the Chief said that it's the role of the Supreme Court in our constitutional system that is at stake. And I think that's really right. And I think, as we think about the court's legitimacy and how actions it takes this term in Dobbs and other cases might affect it, the SB 8 litigation itself was a really devastating and disturbing kind of marker in that story.
Amir, did you want to jump in with a point, or did Brianne cover what you were going to say?
And really briefly on this point about the threat to the court as an institution, this is an issue where 15 different justices over the past 50 years have reaffirmed the viability standard that's now under threat. And if you look at the history of this precise case, you've got the sponsors of the bill grounding it in the fact that they have a new Supreme Court with a new conservative majority. And if you haven't, many people maybe have, but if you haven't, there's a moment that comes about 11 minutes into the Supreme Court argument where Justice Sotomayor walks through this and she says, will this institution survive the stench that this creates in public perception. And she actually says, I don't see how that is possible. And it's quite a statement from a Supreme Court justice.
All right, we need to keep moving along. So we're going to talk next about the shadow docket. Steve Vladeck, you are one of the foremost critics of the way the court has handled the shadow docket, and you're also a person who, as far as I know, keeps the best records about what the court has actually done with regard to the shadow docket. So let's start with this. What patterns or developments have you seen with the court and the way it's handled these emergency cases that people have started to dub the shadow docket so far this term?
Yeah, I mean, Greg, I think we've seen a couple of distinct patterns that aren't necessarily mutually consistent. And so I think I just sort of offer three brief observations. The first is that in at least some respects, I think the justices are starting to hear some of the criticisms, whether they are willing to accept that or not. So, we saw in the OSHA and CMS mandate cases that the court held oral argument on emergency applications for, near as I can tell, the first time since 1971. Right, certainly sometime in the 1970s. That's unusual. I think it's a sign that they're trying to give more transparency to emergency applications with such enormous national implications. We've seen some subtle sort of shifts in how the court handles some of these cases. Right, the Texas religious official in the execution chamber case, the court punted on to the merits docket, I think partly in response. We saw this remarkable concurrence by Justice Barrett in October in the Maine healthcare worker vaccine mandate case, where he says maybe we ought to not be granting emergency relief just because we're sympathetic to the merits. And we've actually seen, Barrett and Kavanaugh not publicly dissenting as the court has denied emergency relief in some more cases like that. So I think there's one thread where we've seen the court actually perhaps responding to some of the criticism and tampering down some of the behavior. But also at the same time, we've seen the court continue to do some of the things that folks like me have been very critical of. So take, for example, the Alabama redistricting case, where, by a 5-4 vote, the court put back into effect Alabama's congressional district maps for the 2022 midterms that two different district courts had held to violate, or at least likely to violate, Section 2 of the Voting Rights Act because they were impermissibly vote diluting Black Alabamians. That decision, which has enormous effects, not just in Alabama, Greg, but as you know, in other states that have felt like they had to follow it, came with no majority opinion. And so, we have no idea why the court reached that decision. Indeed, Chief Justice Roberts, in his dissent, suggested that this was because the justices were rushing ahead to sort of implement a change in the court's understanding of Section 2 that has not yet been made in a case. So, those seem in contrast. But the third point, and the one I think is perhaps the most important, is even as there's this internal tension in some cases where the court seems to be taking some of the criticisms, in some cases where it seems to be reinforcing them, it is still an increasingly significant part of the court's overall work, like it or not, criticize it or not. I mean, if we think about the big stuff the court has done so far this term, right, whether it was how it initially dealt with SB 8, whether it was the OSHA and CMS cases, whether it was the Navy SEALs vaccine case, Alabama redistricting, Wisconsin redistricting, the Clean Water Act decision from earlier this month. These are all on the shadow docket. And so, as the court is trying to figure out sort of how much of the criticism to take seriously and how much it doesn't, I think what we're seeing is just how central a part of the court's work, for better or for worse, these orders have become, and how this really isn't sort of a fleeting COVID-based or Trump-based or nationwide injunction-based phenomenon.
I want to ask you about one specific case that you didn't mention. That's the Remain in Mexico case, because they acted on the shadow docket last year, requiring or leaving it such that the Biden administration had to reinstate this asylum program. And then they heard arguments this week, and the arguments sounded inconclusive. It wasn't so clear which way they're going to go. What do you make of that, especially in terms of this idea that, Justice Kavanaugh says we're not deciding the merits when we decide these shadow docket cases?
Yeah, I mean, I think so. The Remain in Mexico case, I think, is an example of how that's true, right? Which is to say that when last August, the Supreme Court refused to stay the district court injunction that had blocked the Biden administration from rescinding the Remain in Mexico program, that particular rule, and Greg, I think, wasn't a merits ruling, right? That I think it was actually reflecting some equipoise on the part of the justice's part. I think the problem is that for every one of those, right, we get rulings like the ruling the court issued 4 days later in August with regard to the CDC eviction moratorium, where the shadow docket order really was, for all effects and purposes, the last word. Right, and where the court wrote just a couple of pages to explain why it thought the CDC lacked the statutory authority to impose the eviction moratorium. So, I think part of the trickiness and part of why it's hard to sort of do the shadow docket in sound bites is because it is not all bad. I mean, the Supreme Court has to have a mechanism for handling emergency applications, right? There are going to be contexts where, whether you think the court is getting the results right or not, the justices really are going by the book procedurally. There are going to be contexts where you think they got it right but didn't go by the book procedurally. It's my take on, for example, the Navy SEALs case. The issue is that overall, we're seeing so many more of these rulings where a majority of the justices are taking what would have been thought of as procedural shortcuts to hand down rulings that are producing significant and immediate substantive effects, whether they are temporary, as in the Remain in Mexico case, or permanent, as in the CDC eviction moratorium case. And that's why I think, to me, one of the most interesting and intriguing signs of the term when it comes to the shadow docket is one last order we didn't mention, which was earlier this month in a case called Louisiana versus American Rivers, where the justices, by a 5-4 vote, put back into effect a Trump-era rule about the Clean Water Act that I think it can fairly be said makes it easier for states to allow energy plants, power plants, to emit pollutants into navigable waterways. And what was telling about that case wasn't just that there was no majority opinion and no concurrence. It was that Chief Justice John Roberts, who has dissented from some of these other high-profile shadow docket orders, didn't just dissent alongside the 3 liberals, but for the first time, Greg, as you know, right, he actually joined in their criticism of the procedural shortcuts. He actually endorsed Justice Kagan's dissent. And I guess, where I come from, right, if you've lost John Roberts, it seems to suggest that this is not just, liberals and progressives trying to find other grounds for attacking the Supreme Court. This is not, as Justice Alito suggested in a speech at Notre Dame Law School right on the eve of this term back in September, in effort to intimidate the court. These are genuine concerns. I mean, I think that's why, if John Roberts is the canary in the coal mine, right, what we're seeing is, even as the court is moderating some of its behavior on the shadow docket, it is increasingly alienating a justice who clearly is sympathetic to where the rest of the conservatives want to go on the merits, but is not happy with, is not willing to tolerate using the shadow docket to get there.
Chiara, did you have a quick point you wanted to make?
Yeah, just very quickly. I appreciate Steve's point about, the court is listening, but I also was just reminded about Justice Kavanaugh's little dig in Merrill versus Milligan, where he talks about, I think he said it was the catchy but worn out rhetoric of the shadow docket. So
my bad.
There's a little, he's standing his ground, Steve. And so we have to, I think we should, be sensitive to the fact that the court is paying attention, but also there might be some recalcitrance around responding to it in a decent way. But the point I actually wanted to make was just like a broader point about the court is supposed to be not a political branch, right? The legislative branch and the executive, those are supposed to be the political branches, and what distinguishes the court from those branches is supposed to be, it's not political. Like they're supposed to be guided by reason and logic and precedent and not politics. But when the court is making these decisions on the shadow docket, without briefing, without oral arguments, without anything, it just reveals the court, the jig is up, right? It just reveals the court to be purely motivated by politics and not this sort of apolitical reason and logic that's supposed to guide the judiciary.
Or at the very least, it does nothing to dispel that charge. And I'm struck. I mean, Greg, you covered Justice Barrett's speech at the Ronald Reagan Library right in early April, where Justice Barrett, I think, with an eye toward Dobbs and some of the other big decisions coming down in the next 2 months, says don't just sort of react based on who writes the opinion, like read the opinion. Right. And, we don't expect you to agree with our principles. We expect you to agree that we are deciding the case based upon principles. And the irony of giving that speech on Monday, April 4th, when 2 days later she signs the unexplained order in the Louisiana versus American Rivers case. What do we do when there's no opinion to read? I mean, that seems to be one of the real problems here.
Right. We need to move on to the case that I think is going to be my biggest headache of the term, and I'm hoping that Brianne Gorod will sort it out. That's the EPA case of West Virginia versus EPA, the case that is trying to limit what the EPA can do with regard to curtailing greenhouse gas emissions from power plants. Brianne, this case has kind of a convoluted history, and it seemed, at least to me, like the court was being fairly aggressive in agreeing to take it up. And then the arguments happened, and I'm not quite sure what to make of them. Can you tell me when the court eventually rules in this case, what are you most going to be looking for?
Yeah, I think you're absolutely right that this case, which is an incredibly important case, both because of what it is about and because of some of the doctrines that are in play in the case that could have even broader implications, it is a real test of the aggressiveness of this court's conservative supermajority. And so I'm going to be looking both to see whether they reach a merits decision in the case, and then if they do, what it looks like. So I think it might be helpful to just provide a really brief background, because as you say, the history here is a little convoluted and a little complicated, and it's important to understanding this point about whether the court should be hearing the case at all. So back in 2015, the EPA issued what was called the Clean Power Plan rule. This was a rule designed to limit carbon dioxide emissions from coal-fired power plants. That rule was challenged in court, and it was never implemented. We were just talking about the shadow docket. To me, this is one of the early, really egregious examples of the shadow docket, because the Supreme Court put this rule on hold without there ever being a merits ruling from any court. So that happens in 2016. Fast forward a few years, the Trump administration comes in, and the Trump administration, EPA, purports to replace that rule, the Clean Power Plan, with a new rule called the ACE rule. And they said, look, we don't actually think that the EPA has the authority under the Clean Air Act to authorize the Clean Power Plan, so we're going to rescind it. That rule, of course, is itself challenged. And so last year, early in the year, the DC Circuit held that the EPA's justification for rescinding the Clean Power Plan was wrong, that the Clean Air Act does indeed give it the authority to issue the rule, and so vacated the ACE rule, which had repealed the Clean Power Plan. But what's really important to know is that the DC Circuit did not put back in place the Clean Power Plan. And in fact, the EPA has said, we're not going to try to put back in place the Clean Power Plan. The emissions guidelines it was striving for have already been met. We're not trying to put it back in place. We're not going to put the ACE rule back into place. We're going to try to put in place a new rule dealing with this, writing on a totally clean slate. And that's important to know, because that was one of the big questions at argument, was whether the court has the authority to hear this case at all. What the EPA's defender said was there's no rule here. So it's unclear how anyone can be injured if there's no rule in place. And it seems like what the EPA's challengers are seeking is really just an advisory opinion to guide the EPA as it develops this new rule. And so, the court's conservatives tend to have a fairly robust view of standing and on limits on the court's authority. And so the question is, are they going to disregard those strictures here because they really want to reach a merits ruling about the scope of the EPA's authority? And then the other question is, if they do reach the merits, like how far do they go? This should be a really straightforward question of statutory interpretation. What does the provision of the Clean Air Act mean? Look at its text. What does it tell us? But when you look at the text, I think it's pretty clear that the EPA does have the authority to certainly do more than what the petitioners, the challengers are saying it can do. It has very broad authority. And so the EPA's challengers are also relying on this doctrine called the major questions doctrine. And one of the most interesting things at argument is it's not clear what exactly major questions is. Like, that was something the justice asked a lot of questions about, trying to understand, where does this come from? What does it mean? How should it apply? But what the EPA's challengers are basically saying is Congress has to speak with unmissable clarity if an agency is going to address matters with major political or economic significance. And they say that we have to have this kind of rule in order to apply what's called the non-delegation doctrine, this idea that there's a strict limit on Congress delegating legislative authority to agencies. So I think that's totally wrong as a matter of constitutional text and history. We actually filed a brief in the case on behalf of one of the leading scholars in this area, Professor Julian Davis Mordison at the University of Michigan, making clear that you look early in the nation's history, Congress repeatedly approve sweeping delegations of policymaking authority over the most crucial issues facing the country. So it's wrong as a matter of constitutional text and history, and the court doesn't really need to reach it here. An argument, Solicitor General Prelogger, told the justices, this case doesn't involve major questions because the Clean Power Plan wouldn't have had major consequences. In fact, the energy industry achieved what the Clean Power Plan was hoping they'd achieve a decade early and without any federal regulation ever being in place. But this is a really big deal because, major questions doctrine has been invoked all the time now across a range of different issue areas, from, challenges to the federal government's efforts to address the COVID pandemic, to other environmental cases. It's coming up a lot in a big Clean Water Act case the court's going to be hearing next term. So, what the court does here and what it says could have really far-reaching implications, well outside the scope of this particular case.
Does anybody else want to jump in on something here? Okay, well, if not, let me ask you one follow-up question. There's a suggestion that the Solicitor General raised, at least in the briefing, about kind of an off-ramp of basically just vacating the DC Circuit opinion. I believe she cited Munsingware to do that. Does that seem like a viable alternative in this case?
Yeah, it's just such a weird case, given that there is no agency rule currently in place for the court to consider. And so, I think you kind of sense this, maybe at the argument, some hesitation now that they actually have the case in front of them and they're realizing kind of how little in some sense is at stake, to find an off-ramp and not use this case as a vehicle for making, major decisions about really anything. So I think that's, definitely something that, you could see happening. It will definitely be interesting to see where the court ends up going, because there are lots of different possibilities.
Throw it out there again. Anybody else want to jump in on something on this case? Brian, do you know what's Amir? Go ahead.
I was just going to jump in briefly because I think the major questions doctrine deserves a little bit more air, given how concerning it is. We're really talking here about judges in robes deciding what issues are too important to have been decided, by the written law. And that's quite an extraordinary thing, even if limited to the non-delegation context. We often talk about having a government of laws and not a government of men. But this doctrine, if pushed to its, the way that it was suggested at oral argument, where it was kind of described as, well, this would seem kind of surprising, was the language that the Chief Justice used at oral argument. If that's truly the way the doctrine is going to be applied, then you really do have, justices in robes deciding when the law will apply as it's written and when we'll just assume that it shouldn't because it's kind of surprising to those people. So it could end up being quite an extraordinary thing and something worth following.
Yeah, I think that's a great point, particularly given the number of justices on the court who self-identify as textualists. This is a doctrine that is completely atextual. It's really an excuse to ignore the text of the laws that Congress has passed. And I think you saw, Justice Coney Barrett really grappling with that a little bit at the argument. How can you, if you think you want to follow the law as written, how can you use this as an excuse to basically make, fairly subjective judgments about what is important, what is significant, and therefore Congress couldn't possibly have meant what it said.
Steve, I'm torn because my clock says I'm supposed to move on now, but you indicated you had something you wanted to say about this topic.
Just really, really quickly, just that I think, and on top of the oral arguments, I would encourage folks to go back and also look at Justice Gorsuch's concurring opinion in the OSHA vaccine case, where I think he actually gives up the ghost a bit about the sort of blurry analytical line between the major questions doctrine and the attempt to resuscitate the non-delegation doctrine more holistically. And I think that's, if the court doesn't Munsingware or find a standing issue in the West Virginia case, I think that's where this is headed. There's a larger point, Greg, that I think we can save for later about the rise of Munsingware, which I think is going to come back into the fold with the CDC mask mandate probably this time next week. But I think we can save that for Q&A.
Okay, let's move on. Steve, stay there because we're going to talk about Egbert V Bully, the case involving whether you can press a First or Fourth Amendment Bivins suit against a Border Patrol agent. I confess this is the case we're talking about that I know the least about. So let me just frame it for you this way. Is this a case about expanding the Bivins doctrine or contracting it?
Yes. Right. So I think the short version, Greg, is the Bivins doctrine, just for the folks who aren't me, I guess, right, is right. This is the 1971 Supreme Court decision that recognizes circumstances in which, when a federal officer violates constitutional rights, a claim for damages can be read directly into the Constitution, since for better or for worse, Congress has never actually expressly authorized such a damages suit, unlike for state officers. The Supreme Court, as I think folks know, over the last 35, 40 years, has steadily pared Bivins back. I actually was counsel for the plaintiffs in the most recent Bivins paring back case, Hernandez versus Mesa in 2020, the cross-border shooting case. But what's interesting to me, Greg, about the Egbert versus Belay case is the petitioners in this case, the Border Patrol officer, one of the questions they had presented was asking the court to actually overrule Bivins in its entirety, a position that 2 justices had endorsed in Hernandez in 2020. And as you know, the court actually didn't grant cert on that question. Which suggests that, one of 2 things is true. Either the court's just going to find yet a further sort of slice to take out of Bivins, or it's possible that the court's finally going to say, we haven't killed it altogether, right? That Egbert versus Belay, this is a case about a Border Patrol agent engaged in what was apparently retaliatory action against an American citizen who runs a little a lodging right by the Canadian border, accused of being a sort of a smuggler. And there are 2 different constitutional claims. There's a Fourth Amendment claim, which really is at the core of Bivins, that the federal officer engaged in unreasonable search and seizure. The First Amendment claim is a little more novel. And so I think part of the sort of the messiness here is that I think it's very unlikely the court is going to recognize the First Amendment claim. That would be a pretty significant expansion of Bivins. But Greg, I think the interesting question is, will the court perhaps sustain the Fourth Amendment claim? Which I think would be a very big deal, because even as the court has pared back Bivins, it hasn't disrupted the notion that in core law enforcement unreasonable search and seizure cases, there's still work for that doctrine to do. It is still possible for American citizens to obtain damages when the government violates their rights. Whatever the court says in this case is going to be pretty significant for whether that's going to be true going forward. And the fact that the court isn't considering whether to overrule Bivins altogether suggests that there is at least some consensus among at least 5 of the justices, right, to keep at least some part of Bivins alive. Not nearly enough from my perspective, but more than nothing.
Let me see if anybody on the panel wants to chime in here, since I've fessed up that I don't know as much about this case as perhaps some of the others. Brianne, go ahead.
Sure. So, I was just going to point out that, this is actually just one of a number of access to court cases that the court is hearing this term. There's a case about whether an Iraq war vet who was injured and then wasn't accommodated by his employer, the Texas Department of Public Safety, whether he can sue. As his counsel pointed out at the argument, if you've been employed by a local sheriff's office or by the U.S. Marshal, he could have sued. But because he's employed by the state of Texas, Texas is saying that sovereign immunity bars his suit. There are a couple of important cases about arbitration, whether individuals who have claims against their employers can go into court or instead have to arbitrate. And, these cases, all of them, tend not to be the kind of big blockbusters that gets a lot of attention. But they're all, I think, both individually important and collectively really important because, a critical part of our constitutional system is the courts, and they're supposed to be there to provide legal redress when people are injured. They're supposed to provide a means of holding individuals and employers accountable. And, all too often, I think a story we have seen from the Roberts Court is the court closing the courthouse doors and making it, more difficult for individuals to get into court, to hold corporations and other individuals accountable. I mean, even today we had a decision that I think is relevant to that story. Steve, did you want to talk about Cummings?
If Greg doesn't mind.
Have at it.
So, just, today, we had 2 decisions from the Supreme Court today, I think neither of which were in the blockbuster cases folks have been waiting for. But, in Cummings, you had what I think we can now call the standard 6-3 split on a question of whether emotional distress damages are available under the Rehabilitation Act and the Affordable Care Act. And by a 6-3 vote, the court said no in an opinion by Chief Justice Roberts. And I think as some folks picked up on offline, this is a really big deal, not just from an access to courts perspective, but for anti-discrimination law more generally, because one of the major premises of anti-discrimination law is that discrimination causes emotional harms and stigmatic harms that may not manifest as economic harms. But if these kinds of damages are not going to be available for spending clause statutes, for statutes where Congress's regulatory power is tied to the spending of funds, which is basically what the Supreme Court held this morning, that really narrows not access to the courts in the abstract, but the kinds of relief that those who are the subjects of unlawful discrimination are going to be able to retain from federal courts. I don't think this is quite as ginormous a decision because Congress could, in theory, fix this. Congress could make this more express in the statute. But of course, every time we say that about any of the court statutory interpretation cases, we have to consider that against the backdrop of a Congress in which very little is actually happening or likely to happen. So, not a blockbuster case, but one that I think is deeply in line with the trend, to me, the troubling trend that Brianne was discussing.
Chiara, did you have something to add?
Yeah, just very briefly. I just want to make a broader point about access to courts. And so I think the received wisdom is that, folks with, politically conservative views would like to constrain access to courts. But I think it's important to recognize that that's only with regard to some categories of cases, some categories of claims, right? When it comes to anti-discrimination, absolutely, like inaccessible courts, that's the goal. But when we look at, what Brianne was talking about with regard to West Virginia versus EPA, should the plaintiffs be in court right now, it's very likely that they don't have an injury. It's very likely that they're asking the court to issue an advisory opinion, which federal courts don't do. And also, just to bring it back to abortion and SB 8, Texas has thrown open the courts to everyone who wants to seek civil damages against anyone who might be performing or assisting in performing an abortion. And so the sort of received wisdom about conservatives wanting to make courts inaccessible, it's just not a complete view. It's only inaccessibility with regard to certain categories of claims.
Okay. Well, let us move on to Thompson v. Clarke, which is the case of a man who tried to sue under Section 1983 for malicious prosecution after the charges against him were dropped. His case never went to trial. And it turns out that he can press that suit. And Amir Ali, you argued this case on the winning side. So tell us why you won.
I'll give it my best guess. I'll just say this comes in one of those areas that Chiara just mentioned, where people generally expect the court to be constraining access to the courts because it's about law enforcement accountability, where we've seen, at least this precedes the current supermajority, conservative supermajority we've seen over the past decades. Really a trend towards less accountability for law enforcement. And so hopefully this does give some reason to be optimistic. Why we won, one of the reasons this was surprising, I think, to some, beyond just the fact that it involved accountability to law enforcement, was that we were really challenging the rule as it applied in all of the country until very recently, and the vast majority of the country, before the 11th Circuit had split off and taken our position in the case. And if you read Justice Kavanaugh's opinion for the 6-justice majority, it reads as a very technical opinion. And if you read the question presented, you might say, what the hell is this case about? It says, we're talking about the favorable termination requirement for a claim of unreasonable seizure pursuant to legal process. And if you read that and think like, I think that you're kind of in the same position as most people. I think the way we won this case was multifactored. First of all, we had a very compelling principled argument that we were able to translate to multiple ideologies. And, that shows, from the court's opinion that crossed the political spectrum. And it shows from the coalition of folks we were able to get in favor of holding police officers accountable. So the issue in the case, setting the legalese aside, is really about, can you hold a police officer accountable when they frame an innocent person for a crime and pursue false charges against that person? Unless you think that's something that doesn't happen ever, or you feel kind of removed from the possibility that might happen to you, I'll just say that it's documented that this happens most often in a circumstance called cover charges. So this is when an officer engages in some sort of abuse of authority. Often it's an unlawful stop or search, or maybe it's using excessive force against someone. And after the fact, in writing the police report or the affidavit, justifies that abuse of authority by saying that someone resisted arrest is the most common, or that they obstructed the officer in some sort of way. And you don't have to take my word for it that this is a concerning practice. There's actually police departments across the country that monitor the number of times different officers are accusing folks of resisting arrest, because they know that those sorts of charges are used as cover charges. So that's kind of the common everyday version of this. The kind of more extreme version, I'm in DC, you could pull up Google and watch videos of police officers in Baltimore planting evidence against innocent people. So this happens. And the question in this case is, can you hold the officer accountable? Because when this happens, whether it's the kind of cover charge version or the more egregious version, I suppose, it can really upend someone's life. You have the criminal process starting against that person. They may, as Mr. Thompson was in this case, be jailed on account of those charges, have to face and show up for criminal proceedings over the course of months and years. And then ultimately, Mr. Thompson in this case was able to get the charges dismissed. And what the law said across the country was that means he can't hold the officer accountable. Once the charges are dismissed, the officer is immune from civil accountability. And the reason court said was that you hadn't shown that you were actually innocent. You'd only defeated the false criminal charges. And that's the rule we took on. And we took it on and really invested in building a coalition of folks. We had prosecutors who weighed in our side. We also had the Constitutional Accountability Center weighing in on the importance of the breadth of this civil rights statute. But we had conservative organizations. We had law enforcement coming in and saying, this is a situation in which police officers need to be held accountable because it actually increases confidence in the officers. And then beyond that, we had really what the Constitutional Accountability Center does best, which is we had the history on our side here. There really was no historical basis for the rule that had been applied across the country. And so, we hit it from all of those angles, hoping that it would stick with 5 justices at least, and we ended up getting 6.
What does this case say about the difference between Justices Kavanaugh and Barrett on one hand, they were on your side of the case, and Alito, Gorsuch, and Thomas?
Well, in this particular case, the main issue, I think that kind of unfolded at the oral argument itself, which ended up lasting almost double the time I was allotted. And the reason was that the justices who ended up in the dissent really wanted to push back on sticking to the question that the court had granted, the question presented about, whether the dismissal of charges somehow extinguishes your civil claim. And they wanted to go further and just say, this claim doesn't exist at all. And so the Justice Kavanaugh, Justice Barrett, the Chief Justice were in the majority. All of them, and they indicated this kind of at oral argument, were inclined to stick to the question presented and answer it in our favor. What's interesting about that when you read the opinion is that, and this is, I guess, the beauty when you have Justice Kavanaugh on your side writing it and those justices on your side, is that they didn't really just stick to the question presented. Justice Kavanaugh's opinion recognizes that this is a claim. So he didn't assume it was a claim. He didn't, bracket that question for the future. He recognized this is a valid claim and then decided the question presented regarding that claim in our favor. And so, at oral argument, I was dancing around this apparently more than I needed to, because in the fashion that can be very concerning in the other contexts we're talking about, but, I suppose, paid off here, Justice Kavanaugh just brushes off the dissent aside and says this is a real claim, and the petitioner wins.
Let me throw this open to the other panelists. Anybody have some thoughts or questions they want to interject? Go ahead, Brianne.
Well, I was just going to say that I think this whole conversation underscores, how important it is to talk about getting into court, which we've obviously already been talking about. We spent a lot of time talking about the scope of the rights recognized by the court, but you need to be able to get into court. in order to vindicate those rights and make them real. And this was such an important win. I just thought I'd flag another area where I think the fight for accountability continues. And this is a conversation we've had before at these home stretch discussions, and we'll almost certainly have in the future, which is about the fight against qualified immunity. I was thinking about one of the cases that I think we talked about last term at the home stretch, one of the Fourth Amendment cases, Torres, which was about whether someone is seized within the meaning of the Fourth Amendment if they're shot but temporarily elude capture. And what's so interesting is there's a tendency to focus on cases the court hears, the court issues decision, and then everyone stops paying attention. Well, even though that was a win at the court, when it went back on remand, the officers were granted qualified immunity, which is this judge-made doctrine that has made it really difficult, in some cases impossible, for many victims of unconstitutional action by state and local officials to get redress in the courts. And so, there are petitions consistently being filed with the court asking them to take up qualified immunity. There's actually one the court is considering now called Cope v. Cogdell, which it has relisted 3 times. That means it's been discussed at multiple conferences now. Clearly, at least one justice has some interest in it. So I hope, at this time next year at Homestretch, we're discussing that case or some case raising qualified immunity and giving the justice a chance to really revisit that doctrine and, at the very least, make clear that it should not be an insuperable barrier to people getting into court when their constitutional rights have been violated.
It is time to open it up for press questions or for questions to the audience in general, but we'll prioritize ones from my colleagues in the press, and I'm going to take the moderator's privilege and ask the first one on a case we have not discussed, which is the New York State Rifle Association versus Bruin, the case about whether there is a constitutional right to carry a handgun outside the home for self-defense purposes. If you do like me and try to read tea leaves based on who has written opinions in a given sitting, it appears as though the author of this opinion will be either Justice Thomas or Justice Barrett. And so my question for the panel, anybody, is what is the difference between those two? What would a Justice Barrett opinion look like in a way that might distinguish it from a Justice Thomas opinion? Does anybody want to jump in on that? Go ahead, Steve.
So I think I'd say 2 things in response to that, Greg. I mean, the first is I would add the Cummings data point from this morning, which is the Chief Justice writing one of the 9 opinions from the December sitting also suggests that he's not writing Dobbs, which I think ties into the Barrett conversation a bit. I think the difference is very much, I think, where I am not sure of the difference in the 2 potential outcomes. To me, if it's a majority opinion by Justice Thomas, I suspect that it's not only going to strike down the New York licensing regime for public carry, but really articulate a pretty broad-based right on the part of individuals, at least most individuals, to possess firearms outside of the home, a ruling that's going to call into question laws not just in New York, but in a number of other primarily blue states that do restrict public carry of firearms. Here in Texas, it's not going to have much of an impact, but I think the Thomas Barrett distinction, I think a Thomas opinion is likely to be broader. I could see a Justice Barrett opinion that finds problems in the New York case, perhaps with how New York has applied its licensing system, without suggesting that all licensing requirements for public carry are unconstitutional, and perhaps leaving plenty of room for states to have robust but sort of meaningful licensing regimes where there are objective criteria that are applied reasonably that actually allow for some people to obtain licenses, as opposed to New York where it's been a virtual impossibility. Greg, I think the critical point is, regardless of that, either way, I expect there's going to be real pressure on the majority to not just resolve Bruin, but to actually try to make bigger, broader principles to guide how lower courts should approach a whole range of Second Amendment questions going forward.
Kiara, did you have something to add?
Yeah, I was just wanted to add that if Justice Thomas writes the majority opinion, then there'll be something in there about race. I don't think that Justice Barrett is prepared to talk about race, but we've seen Justice Thomas deploy race in contexts in which, usually only, progressive scholars would raise the issue of race. And so he had his concurrence in Fox versus Planned Parenthood, where he talks about abortion as a technique of Black genocide, not briefed at all, but he talked about it. His entire concurrence in McDonald versus City of Chicago, he focused on the importance of gun rights and gun access to Black liberation. And so I think that, Justice Thomas would take up the invitation that the defender's brief, I think a lot of people talked about the public defender's brief, in which they argued that the licensing statute in New York should be struck down because it's really just a technique for searching and seizing and committing violence against people of color in the way that it has been enforced. And so I think that, Thomas would put a racial justice spin on the case that Justice Barrett would not. And that allows me to segue into, thank goodness, Justice Ketanji Brown Jackson will be a new addition to the court so that she can counter the sort of racial narratives that Justice Thomas has been able to spin uncontested in his opinions on the court.
I ask all of you guys if over the course of this term, there have been any dogs that didn't bark, any cases the court has not taken. And I thought of this when Breanne talked about qualified immunity. And at the beginning of the term, I think there was some hope among some people that the court would take up a qualified immunity case. And so far it has refused to. Are there any other areas of the law that maybe have surprised you that the court hasn't gotten into or that you think is noteworthy? Kira?
Yes, I'm going to respond to your question by not responding to your question and by simply saying that I think I have been surprised at the speed with which the court is moving to undo the precedent that folks on the left have held dear. I'm looking to next term now. We know that the Supreme Court will be hearing the affirmative action litigation, Harvard and North Carolina. And so no good result will come from that with the currently constituted court. So again, like the velocity with which the court is moving to overturn the precedents that they don't like, to realize a conservative vision of the country, I think is been shocking, only because we had hoped that it would take a long time, but it seems like it's moving pretty quickly.
Steve, did you have something to say?
Just very briefly, I mean, it's interesting. There haven't been a lot of, I think, really visible dissents from the denials of cert. Right, with maybe the biggest one I can think of is the Sotomayor Gorsuch one in the FISA public records case. But when it comes to dogs that haven't barked, I mean, I will say, since I live in shadow docket land, everything seems to be important there. There have been 7 or 8 big high profile shadow docket cases where Thomas Alito and Gorsuch dissented from the court's refusal to intervene. And most recently, we saw one this week. With the Thomas Jefferson High School affirmative action case, where, I think that that's a sign, Greg, to me, that even with the, to me, problematic behavior we're still seeing on the shadow docket, there are contexts in which Thomas Alito and Gorsuch are publicly flagging that they are willing to go even farther, even faster, to pick up on Chiara's point, than we don't know for sure how many of the other 3 conservatives, but then certainly at least 2 of them. And so, I think this is, to me, there's more to see of that split, at least to this point in the term, in when the court hasn't intervened in emergencies, or at least putative emergencies, than on the merits docket thus far.
Okay, so we have about 2 minutes left, but very quickly, what else next term besides, we mentioned the university admissions cases, we've mentioned the Alabama voting rights case. What else is gonna be really hot next October? Steve?
Remember the Masterpiece Bake Shop case from a few years ago, which was set up as this massive conflict between the religious exercise rights of private store owners and private business owners and the anti-discrimination rights of LGBT customers. The court really ducked the issue in that case by focusing on a very case-specific issue, the perceived animus of the Colorado Civil Rights Commission toward the Baker, in that case, Jack Phillips, the court has granted cert in a case called 303 Creative for next term, where there's no apparent case-specific off-ramp, where the big constitutional question the court ducked in Masterpiece Cake Shop is going to come really to the fore. And I'll just say, I mean, I don't think this is going to surprise anybody. This is a very different court to be deciding that question than one in which it was up to Justice Anthony Kennedy. And so I think, that's going to be a really important case, not in the same pantheon as, the affirmative action cases, the voting rights case, and so on. But that case, and I'd also just quickly flag the Indian Child Welfare Act case, that is super complicated, but also super important for Congress's power over tribal relations, and over tribal law more generally going forward.
We're going to have to leave it there. Thank our panelists, Steve Laddick, Amir Ali, Brianne Garad, and Kiara Bridges. Thanks to Elizabeth for putting this together, and Doug Pennington. And thanks to everybody for listening. We'll do it again next year.